If the professors are ready, we can go ahead and get started.
Yep.
Okay, just a quick introduction. So my name is Gabby Wembley. I'm co-president of the Federalist Society at Georgia State. Along with ACS, I'd love to welcome you to this event. So we're going to be discussing what is next for Trump today. I'm going to keep introductions short since we have a lot to discuss. We have our very own Professor Siegel from Georgia State. Thank you for being with us today. And we also have a guest professor, Jonathan Adler. He's from Case Western Reserve, and we really appreciate you making time to discuss with us today. Basically, the structure of this conversation is going to be a professor to a question to one professor and then a question to the other. Each professor will have time to respond to the other professor's answer, and we'll just go through. We will have time for Q&A at the end, so this should be a great discussion, and thank you very much for being here with us today. So with that being said, we're going to go ahead and throw the first question to our guest, Professor Adler. So can and should the Senate convict Trump? What are your thoughts?
So there's a lot there. So in terms of the immediate question, can the Senate hold an impeachment trial of Donald Trump now that he's left office? I think the answer is yes. I think that the text, structure, and historical understanding and application of the relevant provisions of the Constitution all point in the same direction. I reject the argument made by folks like Judge Luttig and Alan Dershowitz that you cannot have a trial of a federal officer that has already left office. I think the primary reason for that is that disqualification is one of the potential consequences of an impeachment conviction, and a structure that allows any federal officer to simply avoid that potential result by resigning would not be very effective. I also think it's worth noting that the power of impeachment, as it was understood by the founders, as it had been used in England, as it had been used in the various states, did allow for so-called late impeachments, did allow for individuals to be impeached even after they had left office. And there's nothing certainly nothing that I've seen in the founding era materials that suggests that that was an aspect of impeachment that they sought to corral or alter in any way when including it in the Constitution. And then we have seen the Senate assert jurisdiction to conduct trials of impeached officers after they had left office, including the famed Belknap case where we did have someone try to resign to prevent that from happening. The question, I think, is a more complicated question, and I would just divide it into there are two aspects of that question that I think we want to separate. One is, did Donald Trump commit impeachable offenses? I think the answer to that is yes. I think that I've thought that for a long time. In fact, as I often point out to folks, I believe that before Nancy Pelosi did. That is to say, I think the House was actually slow in opening impeachment inquiries. And I think that actually had practical consequences. Among other things, it constrained the sort of information that the House could obtain. It unnecessarily constrained the investigatory authority of the various committees because they weren't willing to rely upon their impeachment power. They rather tried to pretend that they wanted, for example, the president's tax returns because they wanted to use him as a case study for a reform of various tax laws. And we all know that that was nonsense. So have impeachable offenses occurred? I think the answer is yes. I do think that, and Alexander Hamilton talked about this, I believe in Federalist 65, if I'm remembering correctly, there is a prudential question, a question of prudential judgment that should come into play in the context of an impeachment trial. I think were I a member of the Senate, I think I would vote to convict, but I also think that I would want to approach the debate in the trial and the arguments with an open mind. And I think there is a prudential judgment about whether conviction in fact serves the underlying purposes. And that's ideally something we elect politicians to make those sorts of prudential judgments. But in terms of the merits, were there abuses of power? Were the sorts of betrayal of a constitutional oath that are impeachable and convictable? Yeah, I think the answer to that is yes, and I base that largely on the way impeachment was understood in the founding era and the sorts of things that the founders thought that should constitute impeachable offenses. Unfortunately, Eric probably agrees with a lot of that. But
so I certainly agree that an officer can be impeached after he leaves office or she leaves office. I think that's clear from the historical record. The text of the Constitution is silent on it. There's no time limit in the Constitution. I think that's a big deal. And in any event, I think it's a political question for the Congress. I don't think the Supreme Court would ever get involved in second guessing that kind of judgment because it's kind of an indirect argument, but obviously this doesn't involve judges, but the only way to get rid of judges, federal judges, is through impeachment. And the justices are very reluctant to get involved in laying down big impeachment rules when that's the only way they can be gotten rid of. So I think Jonathan is right about all of that text history and all that. I think the should question is really interesting. And this is where some people might be surprised. So on the one hand, I think we all have, strike that. Many of us have an emotional need to punish Trump for all the awfulness of the last 4 years. And he clearly committed impeachable offenses by his call to the Secretary of State in Georgia and all kinds of other things that he did. So I think the Mueller report, when read fairly, constitutes probably an impeachable offense. So I think they could do that, but that isn't really the question. The question is, will the Senate convict him? Because if the answer to that question is no, then we should not have an impeachment trial. Because if he goes on trial in the Senate and they don't convict, that will be deemed, by many as some kind of, cleansing of his awfulness. And I think that would be a terrible, terrible mistake. I also think the impeachment article that the House drafted was really poor. The phone call should have been a second article, and they should have gone back and drafted all kinds of other articles about all kinds of other terrible things Trump did while in office. Looking at it from the political perspective, so if you're Ted Cruz or you're anybody really other than Mitt Romney who's going to run for president next time, you probably can't vote for conviction because you will lose Trump's base forever. And if you lose Trump's base forever and you're a Republican, Jonathan may know more than I do about this, but I don't think you can win. So they're going to be whoever's running for president on the Republican side in the Senate, they are not going to vote to convict other than maybe Mitt Romney. So that worries me a lot. And I think it does to some degree come down to McConnell, which is always, this is partisan, a very scary thought. But I'm pretty sure he wants Trump gone. I would bet a lot that he would like to see Trump disqualified from office, and gone. The problem is, does he have enough votes for that in the Senate? And I don't know. And then there are a couple other arguments why maybe we shouldn't do it. Maybe it is time to move on. Why can't Schumer come out and say he was a terrible man and a terrible president, and we don't want to think about him anymore, and we're moving on to more important things, and we have COVID, and we have racial injustice, and we have the Supreme Court. There's a part of me that doesn't want to even hear about Trump anymore. And I don't think that would be a terrible decision. But at the end of the day, from obviously a progressive perspective, but I think from the perspective of most people who are not Trump supporters, and that includes many Republicans, how do we minimize his impact? That's the question. And I'm not sure an impeachment trial minimizes his impact. So I'm not sure what the Senate should do. And if I was running the Senate, as Schumer now does to some degree, I think I would be very careful and very torn about it.
Perfect. Thank you. So this is the next question for Professor Siegel, touching on the 14th Amendment. So can and should Congress use Section 3 of the 14th Amendment?
So I've evolved on this question. And I've evolved in a very short time on this question, because of Twitter, by the way. At first, I thought, yes, Section 3 of the 14th Amendment says that if you've taken an oath to support the Constitution, meaning you're a government official of some kind, and you engage in insurrection, then you can't hold office. And I think there's even an argument that from the day of the insurrection, everything you do is null and void. That's a more controversial argument. But Professor Mark Graber of the University of Maryland, who is one of this country's leading experts on the history of the 14th Amendment, suggests strongly that if Congress would have voted by a majority of both houses that Donald Trump engaged in insurrection, it's possible all the pardons he issued would be null and void. Here's my problem. Jed Sugarman, a law professor at Fordham, who I respect a lot and is very thoughtful, got mad at me at Twitter for suggesting that we should do this. And his point was, this is an awful weapon to give to such a political body as the United States Congress. And, in 1868, maybe it was a good idea to say that former members of the Confederacy, leaders couldn't hold office. Of course, that was a good idea. But today, majority vote in both houses, and all of a sudden we get people who engage in protests on the left who have taken an oath to uphold the Constitution. Now they're engaging in insurrection. And I think he's convinced me that's probably right. So my answer is we probably should not go forward. The Congress shouldn't go forward with Section 3 of the 14th Amendment. I also want to say it breaks my heart to give that answer.
So I reach the same end result as Eric. I do it slightly differently. I mean, I think that the language of Section 3 talks about engaging in an insurrection. I don't think Trump's conduct actually satisfies that. I don't think it's a justiciable question. That is to say, I think if Congress sought to act on it, I don't think a court would disturb it. But if I were a counsel to a member of Congress who asked me, would it be consistent with our congressional oath to vote to say that this provision has been implicated by anyone who did not, in fact, themselves engage in violent activity at the Capitol, I would advise them that I don't think that it is implicated. I don't think that Trump's comments amounted to insurrection as that language is used. I also think that trying to invoke that after the fact does raise bill of attainder questions that, again, are probably not justiciable, but that I do think are things that members of Congress should take seriously. So I think that trying to invoke Section 3 of the 14th Amendment would be very problematic. If Congress wanted to enact legislation using its Section 5 power of the 14th Amendment to define going forward what constitutes engaging in insurrection for prospectively, so that we have clear lines of demarcation of what sorts of conduct would qualify there, and perhaps to create something of a prophylactic rule that applies more broadly than the language of Section 3 would on its own. I think that's an interesting question. There are a lot of provisions of the Constitution, Section 4 of the 25th Amendment being another good example, that would benefit from implementing legislation that is designed to create clear rules for how those provisions can be made operational. And I'm open to the idea that Section 3 of the 14th Amendment is one of them. But I think trying to label Trump's conduct as insurrection is not helpful. I also think it's constitutionally dubious, and do not think that that's a road that people should go down.
Gabby, let me respond really quick, if with permission. So I wrote a blog post a few days ago about insurrection and incitement and free speech and all of that. And so to some extent, I agree with Jonathan that just the speech that Trump gave, we look just at the words of that speech. And by the way, my co-blogger, my blogger-in-chief, Mike Dorff, actually thinks that was incitement and insurrection. I don't. I think the words of that speech aren't enough. But, and it's a big but, and it ties in the first question. If we find evidence, and by the way, I think this is what happened, I can't prove it, but if we find evidence that Trump knew this was going to happen, that he was happy with it, that he knew what words to use, and that he sat by while it was happening and did nothing, then I do think there is a reasonable case for insurrection. Not saying we should use it as a case, but I do think that's probably insurrection. I don't think it's protected by the First Amendment. And most importantly, if we do find out that Trump had more involvement in that violent takeover, invasion of the Capitol, if we find that out, then my position on impeachment becomes very different. And I think if there's clear and convincing evidence that Trump was directly involved in the Capitol attack, then I think the Republicans in the Senate would almost have to impeach him. And then everything changed.
Perfect.
And the only thing I would just say there, just to really, is that I think that there's an argument that the speech and so on constitute high crimes and misdemeanors because they cross the line of the sort of conduct that we should feel is acceptable from elected officials. But I don't think that's insurrection. And while I think that if Donald Trump's could Donald Trump, were he not president, have been subject to an incitement prosecution for his comments on those days? I think the answer is maybe. I mean, those sorts of prosecutions are really hard. What you actually have to prove in terms of incitement is much more difficult than people think it is. But even if we assumed it was incitement, I still don't think that's insurrection. Right? I think there are gradations of offenses, and I think that that's important to keep in mind.
Perfect. And so this is a slight pivot. So Professor Adler, this is talking about the pardon power specifically. So is there a way to limit the pardon power?
I think it's hard. I think, the pardon power is a very broad power. It is not subject to review in courts other than the formal validity of a pardon. Was it in fact issued and accepted, or issued and delivered and accepted? I think that a lot of the arguments that certain pardons might be invalid because they're self-serving or whatever, I think those arguments are nice, but I don't find any of them convincing. There was one in the New York Times today by Norm Eisen and Steve Calabresi trying to argue that the pardon of Steve Bannon should be invalid. I find those arguments completely unconvincing. I think that we've had norms that have helped constrain the pardon power, reliance upon the Office of Pardon Attorney to process applications and the like. I think those are good norms. I think Congress certainly could enact laws that are designed to try and ensure more transparency about pardons. And I think that some proposals along those lines might work. But I don't think Congress can constrain the exercise of the pardon power. I don't think it can undo pardons. I don't think it could prevent pardons. It can make certain efforts to obtain pardons criminal, right? So Congress could criminalize the paying of bribes for a pardon. But I don't think that Congress can limit the pardon power as it's written in the Constitution. The only limits, again, are those that are inherent in the nature of it. And I'm one of those who believes that self-pardons are not pardons and therefore are not within the pardon power. That is to say, a pardon is a gift. It is something that is bequeathed or given to someone else, not something that one can bestow upon oneself. And so self-pardons aren't valid. But that, again, I think is in the Constitution. So I don't really think Congress can do a whole lot. And should it? I'm torn. I think just as I think we talk about impeachment too rarely, I think that the pardon power and clemency power is probably used too rarely as well. Trump was actually quite stingy with his use of that power in terms of his whole time in office. He did not use it all that much. He just happened to use it in a lot of ways that folks like me find to be very unfortunate. But the use of that as a means of clemency on a more regular basis for people that were overcharged, people that were given over long prison sentences and the like, I think that's a good thing and not something I would want us to compromise or give up.
So this is going to be boring, but I agree with much of what Jonathan said. I do think I don't know how much Congress can do to limit the pardon power because there's actually, I mean, it's an old Supreme Court case, but there's a Supreme Court case, the Klein case, that suggests that the pardon power is pretty much, up to the president at any limit. However, I think it does get harder if we think about it in a different way. So the president has all kinds of powers. He is the commander-in-chief. Let's just take the commander-in-chief power. There is no question the president gets to decide, where the troops go and what parallel the ships are at and what kind of submarines to order and all that stuff. And no one could say that we can limit that. There'd be serious separate. Now, Congress has to fund it. But other than that, I don't, we would all agree that the commander-in-chief power is for the president and the president alone. But if the president issues an executive order, for example, this is very hypothetical, but in 2021, saying, I've decided to segregate the military again. Well, he's commander-in-chief, but that's unconstitutional, right? I mean, that would violate the Fifth Amendment to the Constitution. So when the president exercises his powers, he can violate the Constitution, even though the power is all his. So I do kind of think that there are ways that the pardon, you can't overturn a pardon. A pardon is a pardon is a pardon, that stays. But the process leading up to the pardon, I think, can give rise to all kinds of criminal acts. And I don't think the pardon power protects that any more than the commander-in-chief power protects that. So I would like Congress maybe to, if not pass a law, at least some kind of sense of the Congress that taking bribes, direct bribes to get a pardon, is an act that maybe should have some criminal penalties attached or something. But at the end of the day, to overturn the pardon is not possible unless we go back to Section 3 of the 14th Amendment. But I think that game is not worth the candy.
Okay, thank you. And so the next topic that we wanted to discuss is, so for Professor Siegel, so should there be court reform?
Yeah, well, that's something I've thought a little bit about over the last few years. There unequivocally needs to be court reform. The Supreme Court dictated the 2016 election. And Jonathan and I might disagree on this, but I have the data. I mean, 1 in 5 voters said the Supreme Court was the most important issue, and the percentage is even higher when you ask, was it an important issue? But the most important issue for 1 in 5 voters. And Trump won three swing states by 80,000 total votes. There is no way he wins those states without the list that the Federalist Society provided to him before the election, without making abortion and the Second Amendment and what they call religious liberty and I call religious discrimination an issue in the case. So the Supreme Court, for all kinds of reasons, just plays too much of a role. Now, I really want to be clear about something, and I've written about this in Salon, on my blog at Dorf on Law, and in many other places. Democrats and progressives who are calling on packing the court or stacking the court or whatever they want to call it, that's not what we should do, and the Republicans won't agree anyway. What we need to do is weaken the court, and we need to weaken it dramatically. And I won't go into why I think that, somebody asked, but I wrote a whole book on why we should weaken this court that's not really a court and make these justices less powerful because they're not really judges. And so I think there are two ways to do that are hard, but which don't require a constitutional amendment. The first one is give them 18-year terms and let them serve the rest of their careers on the Court of Appeals. They do have a right to be a judge for life, absent high crime or misdemeanor, but they don't have the right to be on the Supreme Court. They have the right to be a federal Article III judge. Now, there are some who argue that's wrong. They're wrong. And I don't think, by the way, the Supreme Court would get involved in this anyway, but I think we can do that. So that would make the Supreme Court much less powerful. And then my crazy idea in 2016, when Justice Scalia died, I still believe it. We should have an even number of justices, an even number. And the original number was 6. So for those originalists out there, we can have an even number because the original number was 6. And the Senate should have an informal agreement among themselves, just like they've done for the filibuster for over a century. The filibuster is not a law, people. It's not a law. It's an agreement between Republicans and Democrats. They should agree that we should have an evenly balanced Supreme Court, Republicans and Democrats. And I'm not going to go into all the details of that now, but they can do that. Now, the president gets to send over anybody he wants. That's his prerogative. But the Senate can say, no, we're not giving a hearing to that person. We know they can do that because they did that with Garland, right? So if a Democrat dies or retires, give us a Democrat. If a Republican dies or retires, give us a Democrat, a Republican. And if you give us an independent, which is fine, then that'll count against the political party of the person who died or passed away. I have all kinds of other things in there to make that work. But the overall big point is we need Supreme Court reform, not because it's a conservative 6-3 court. That's not the reason. The reason is because from 1857 and the infamous Dred Scott case until today, the Supreme Court has played way too big a role in American society, and we should all be in favor of weakening it, not packing it.
Okay, so we have some disagreement now. First of all, if we want an 8-member court, if Justice Breyer retires this year, like a lot of people think he will, I'm happy to leave the court at 8. But I don't think Eric would go with that. Or the chief could resign, as some people have suggested, and we could leave it at 8 then. In principle, I don't have a problem with an even number court. I think with a lot of the problem with talking about things like adjusting the size of the court is I am very much against doing anything of that nature in a way that is timed to maximize partisan advantage, because it's not something that has been done in a long time for that. We used to add a justice based on every time we created a new circuit. That tradition was broken in the Civil War period, and we've stuck with 9 since then. And so I think if there were to be such a change, we would want to structure the way we adopt that change in a way that creates some distance between those who are adopting it and the benefits that accrue. So, for example, when we've expanded lower courts, the tradition has usually been to try and stage those, the creation of those new seats over time, so as to create a little bit of distance between the members of Congress who are voting in favor of creating new court positions and those who actually get to play a role in filling them. So, for example, the Judicial Conference right now is recommending the creation of a bunch of new seats. I think that there are needs for new federal seats in some parts of the country, in some courts. And my view is you cut them up and a certain number of those seats open every 2 years. And that's the way you do something like that. I think court reform, were it to happen, should be done along those sorts of lines. That is to say, think about what we, whether it's term limits for justices or whatever else, think about what we think the state should be, but then agree to implement it when we're not necessarily sure who the president will be, who would be appointing. Dan Hemel has talked about, for example, instead of term limits, just create a new seat on the Supreme Court every 2 years, just from now going forward, which would probably in the short run result in a larger court, but then the court would probably settle back down to a fairly consistent size. You could do that without amending the Constitution, and beyond the first 1 or 2 times you don't know who benefits from that. I think that could be done constitutionally. I'm skeptical of saying to justices who are on the current court, you are no longer on the court. You now must be on a lower court. I'm skeptical that that's constitutional. That doesn't mean the Supreme Court would strike it down. Again, it's a question of if I were advising a senator or a member of Congress about whether they could vote for that consistent with their constitutional oath, I would probably tell them no, that I'm not convinced that is, to me, that it would be tantamount to removing them from office or lowering their salary. It is altering the terms of the position in a way that I think is too meaningful. In terms of the court and its overall power in American life, I agree that we too many things end up in court. I happen to think that there are jurisdictional ways of addressing that. I think some ways of addressing the court's jurisdiction are certainly worth putting on the table. I would, though, in some respects, go one step beyond that. It's not just that the court plays too large a role. It's that the federal government plays too large a role, particularly in a society like ours where we have such deep divisions and disagreements. across the nation, the idea that we must settle all of these questions for all of the country as a whole, I think is wrong-headed. And the reality is that Californians don't want to be ruled by Texans, and Texans don't want to be ruled by Californians. And rather than channeling that conflict into federal elections, including effect control over the court, I think a reinvigoration of federalism across the board is a way to address these sorts of concerns. So I would apply that to a lot of matters that go to the Supreme Court. You know, if I was a justice, there are a lot of questions that I would not make questions of a federal constitutional law that have become questions of federal constitutional law. But I think in a lot of other policy areas, there are lots of questions that we decide at the federal level and that we don't need to decide at the federal level. There are some questions, like, for example, immigration, where I think it's hard not to decide them at the federal level. But I think there are a lot of questions, marijuana, a lot of basic criminal justice issues, and so on, abortion, that are better dealt with at the state level. And not only because it lowers the stakes, but also because I happen to think that we learn a lot from each other, from other parts of the country, from seeing what other states do and seeing whether or not the resulting costs and benefits of those policies are costs and benefits that we want to bear ourselves. So, quick plug, I have a book on this in the context of marijuana, and there were a lot of predictions that were made about what would happen when Colorado made marijuana available for recreational use. Some people said it would be the most magical, wonderful thing. Some people said it would be terrible. Turned out they were both wrong. And unleashing the laboratories of democracy, I think, would be beneficial for our politics. I think it would be beneficial for the court as well, that we don't expect the court to solve all of these questions. But that's the way I would go about trying to lessen the court's power. I would not focus so much on kneecapping the court as a court.
So I have a few responses to that. First of all, the idea of Supreme Court justices serving on the lower courts, I agree, it can't be retroactive. It would have to be prospective for new justices. So I agree and disagree with Jonathan on that. So in 2016, Justice Scalia dies, and the court is 4-4, and 4 Republicans, 4 Democrats. Now, Jonathan might say Kennedy was kind of more, he's wrong. Kennedy voted conservative 75% of the time. Take away gay rights and 1 or 2 affirmative action cases and a couple others, Justice Kennedy was conservative. So we were 4-4, and everybody thought Hillary was going to win. Everybody. And I went around the country, had op-eds in the New York Times, the Daily Beast, the Huffington Post, saying, this is the moment, right here. We're 4-4. We are evenly balanced. This is not about packing the court. This is not about giving Democrats an advantage, which they're going to have for the next 4 years. Everybody thought, much to our chagrin, it didn't happen. So I think having a balanced court like Delaware has numerous state courts that have partisan limits on the composition. And the Supreme Court had that case before this term inducted on standing. I don't think there's anything unconstitutional about that. Justice Kagan went around the country in 2017 and said, 2016 was pretty good. We had 4-4, and we talked more, we compromised more, we did less. But here's my real stinger to Jonathan, I think. The whole point of my proposal, the whole point of it, is to return abortion, affirmative action, guns, campaign finance reform, and most other very difficult issues to the states. I know ACS doesn't want to hear that, but that's my position. And a 4-4, an evenly divided court will end up returning power to the courts of appeals. And then the Fifth Circuit, which is incredibly conservative, can have their anti-choice, stuff, and New York and California can have their pro-choice stuff, and different regions of the country will be governed. And the only time different regions of the country should be governed by 5 out of 9 unelected, life-tenured lawyers sitting, Ivy League lawyers almost all the time, except for the most recent one, sitting in Washington, D.C., is when there's a clear constitutional error. When in the words of Alexander Hamilton, when there's an irreconcilable variance between a statute and the Constitution. So a really quick way of getting to where Jonathan wants to be is by accepting my proposal. Now I do agree jurisdiction stripping is another option. A friend of mine, Chris Sprigman, has a great article on that in NYU and Law Review, and he and I wrote a prequel to that article in the NYU Journal of Legislation. I do think the Congress can take away the court's jurisdiction, but I think that is actually controversial constitutionally, and it may or may not survive. But mostly, if you want to return power to the states, then weaken the Supreme Court. And a really easy way to weaken the Supreme Court is to have an even number of Republican and Democrat justices.
Okay, perfect. And then, so the next topic also, pivots a little bit, but I think it's very relevant for, this week. So Professor Adler, will Trump's base turn their support to the GOP, or, have recent events kind of soured the relationship? What are your thoughts?
I wish I knew. I think it's a good question. I think that there is a big dispute within the Republican Party about what the party should be. I think some of those disputes are about Trump. I think some of those disputes are about larger questions about where the party sees its base, about whether or not it wants to be something of a workers' party, a conservative workers' party, or whether it wants to be a more limited government party. And what interest it serves. So I don't entirely know the answer to that. One thing that I think is problematic, though, is that there is a portion of the party, or at least a portion of those that supported President Trump, who are in the sways of what is almost a quasi-religious belief system around Q and viewing Trump as a messianic figure and whatever else. And I think those sorts of things are problematic. Now, I don't think that's the only example of that sort of thing going on in our politics. There's a reason why Matt Yglesias has referred to other currents we see socially and culturally as the Great Awakening. And I think that that sort of approach to political questions can be problematic. But it's something that the party will have to deal with. My own view is that losing with principles intact is preferable to losing without your principles intact. And the Republican Party, particularly in Georgia, I think lost without its principles intact, at least for many of the folks in the party and for the Senate candidates. And so I would certainly, if I were asked, I would encourage the party to identify the principles it believes it's advancing and stick to those principles. And if we're up to me, those principles would be principles that are pretty incompatible with Trump's approach to governing. But I think some folks on this know I was a Trump critic all along. I helped put together checks and balances. So I may or may not be representative, but of that. But my view is a truly conservative party that sticks to those principles and is something the country needs, and is something that hopefully the Republican Party can be. But whether it is or will be that going forward, my political prognostication skills are not something I place a lot of weight on.
Actually, they're pretty good. So I think this is one of the most important questions facing America today, and certainly American politics today. What do we do with, pick a number, 20%, 25%, maybe 15%, I don't know, of the American people who view Trump as, in Jonathan's words, a messianic figure? I mean, just saying that sentence is so inconceivable that it makes it hard for me to talk about this because I'm so removed from that sentence. So I think the first thing both Republicans and Democrats have to do is figure out why is that 20%, let's call it 25%. Why is that 25%? Why did they follow this man? Why are they still following this man? What is going on here? Before we can decide how to bring them back into the fold, so to speak. And there are a lot of explanations I think that make sense. Obviously, some people are just angry about their life conditions and the American economy and the 1%. And all of that's fair, obviously. There's obviously abortion and guns and religious liberty. But then why Trump? Because Cruz and Rubio and all those people who had had the same judges and done the same, as Jonathan often points out to his critics on Twitter, the reality is most of the judges Trump appointed, at least many of them, had the same qualifications that most of, Republican judges have. All with links to the almost all with links to the Federalist Society, I should add. So I've been thinking really hard about this. and I guess this is going to sound really hokey, but I go back to the musical 1776. I think this is a made-up line, but I'm not sure. John Dickinson, who's a real person from Pennsylvania, who was against the Constitution, said in opposition in the show to the Declaration of Independence, most men, and we'll call it people today, most people in America would rather protect the possibility of becoming rich than face the reality of being poor. And that's Donald Trump. I think that's what his appeal was more than anything, that he presented this illusion of grandeur that Americans can aspire to. And then you add the race element to that. There's no question racism played a huge part in this. And how do we address people who don't think institutional racism still exists? But more than that, how do we address people who are overtly racist? I'm not smart enough to answer those questions. But I think we should start with improving the economy. I'm sorry, I've been talking a lot recently. Too much. Improving the economy for everybody, I think would go a long way. How we do that's beyond my pay grade. And then we have to come together on race. And that's not going to happen by the kind of violent protests we've seen. It's just not. Nonviolent civil disobedience, yes. Violent protests, no. But I think those are the two areas, the economy and race. Abortion and guns and all that's important, but I actually think the economy and race are more important. And somehow we got to figure out a way to do better on both of those questions.
If I could,
go ahead.
if I could jump back in on that just real quick, is that I do think that there is something important that both Trump and in some respects Bernie Sanders appealed to that I think is important, which is a lot of people believe, with a lot of justification, that Washington doesn't serve them, right? That the counties surrounding Washington D.C. are the wealthiest or among the wealthiest counties in the United States today. That was not the case the first time I spent a summer in Washington in the 1980s. That was not the case when I moved to Washington to spend a decade there in the early 90s. It is the case today. It is the case today that Washington is often non-responsive to the views and concerns of people. And a figure, whether on the left like Bernie Sanders or on the right like Donald Trump, who promises to drain the swamp, to break certain norms, to not engage in business as usual, is appealing to people who believe, again, with a lot of justification, that Congress doesn't enact laws that are responsive to the needs and demands of the American people, that gives power to agencies that are hard to control and act on autopilot, that imposes burdens and both in terms of taxes and regulations, but also in terms of the way these laws are enforced on people in ways that are often unfair and unjust. And then when you combine that with the fact that you see a lot less economic mobility than you used to see in this country, you see much greater barriers to business formation and maintenance in this country, when it turns out that quasi-socialist countries in parts of Western Europe, when you look at the regulatory burdens on entrepreneurship, have a more free market than we do in the United States. A lot of people look at that and say, we need someone that doesn't play by the rules. We need someone that's going to do things differently. I happen to think that trying to use a Donald Trump for that is a recipe for all sorts of bad results. And he didn't even deliver on a lot of those sorts of promises. But I do think it's a mistake to not recognize that there are very real and legitimate concerns about the way Washington, D.C. operates, that if they are not responded to by the elites that are there, that creates opportunities for demagogues and charlatans. And so I'm hoping that we actually get responses to some of those underlying concerns, because otherwise there will be another Trump-like figure, if not from the right, then from the left.
All right, real quick. Sorry, I have a quick response to that. So I do think there's, excuse me so much. I do think a lot of that is true. People want the image of somebody who says, I'm not from, Jimmy Carter ran for president as an outsider, not being part of the DC, inner circle. But it turned out he, of course, was, because he was part of the Trilateral Commission years before he was handpicked by Rockefeller to run. I mean, so Jimmy Carter was no outsider. Trump, it's hard to imagine somebody, if Bernie Sanders were elected president, there was the swamp wouldn't be drained. And of course, the swamp wasn't drained by Trump. And I also think we have to be careful. I don't want to get into a debate with Jonathan about climate change because he knows more about environmental law. He's forgotten more about environmental law than I know. He teaches it. But it does, I don't. But it does, he writes about it. But it strikes me that the kind of libertarian, anti-regulatory value judgment, we have to be very careful about that in a world where private businesses are destroying the planet. And so whatever deregulation meant in 1955, I think we need to be very humble about letting giant corporations destroy our planet. So I just want to add that.
So we're kind of coming up on the end, so we'll go ahead and open it up to for Q&A. So one of our first questions is a request for clarification from a 1L at Georgia State, and he is curious about procedurally, like, how does it work? So can Congress vote to bar a former president from seeking a future federal position without impeachment, like say that had not happened? So how does that whole process work?
It doesn't. As far as I know, there's only two ways: conviction in the Senate and then a separate vote, to bar him from office, or using Section 3 of the 14th Amendment, which I think we all agree is not going to be used. So they have to be convicted in the Senate. That's it. Jonathan, you agree? I'm sorry. I assume Jonathan agrees with that.
Yeah, I mean, the Senate has the ability to handle it how it wants to, right? I mean,
there's no other way. There's no other way.
And then we have a question from Chase. So he says, while you guys have discussed political measures of impeachment and pardons, what are the chances of an Article 3 court bringing charges against Trump, either related to the events of January 6th or other events?
You mean a prosecutor?
Right. I think so.
Yeah.
Yes.
I'm rooting for the District Attorney of New York. That's who I'm rooting for. That's all I'll say about that.
I think assuming that, as it appears, that Trump did not try and pardon himself, I think the likelihood of federal prosecution for things he did in office is relatively low. I think that there are multiple investigations in New York that will proceed. In addition to all the civil suits, my understanding is that there is an investigation in Georgia. There is no question in my mind that the phone call with Raffensperger, had it been a private citizen engaging in similar conduct, that there would already be a federal investigation of that call. Whether or not a case could actually be made to be prosecuted that could satisfy a jury beyond a reasonable doubt that crimes occurred in and around that call, I think, is a closer question. But it would not surprise me if that were ultimately investigated. It would not surprise me if, for example, there was a federal investigation starting with Mark Meadows, whose involvement in that call, I think, also would create a potential liability. As a matter of prudence, though, I think that the current attorney general, or the new incoming attorney general, is unlikely to want to bring federal charges against Donald Trump for conduct that occurred over the last 4 years, unless there really is no other option. And I think if there were an attempt at a self-pardon, I think that is the sort of thing that would rightly provoke an attempted prosecution to eliminate that precedent. But otherwise, I think that the general norm of erring on the side of not trying to prosecute one's political enemies is a good one. I think that if there are prosecutions, they will mostly occur at the state level.
I'm torn a little bit on this question. I agree with Jonathan, you shouldn't persecute your political enemies just because you're a political enemy. Yeah. On the other hand, one author of the torture memo is currently a tenured law professor at University of California at Berkeley, and the other author of the torture memo is a federal judge. That's wrong. That shouldn't have happened. I think that neither one of those people should be in those positions, in my opinion, because one works for the state. One works for the state of California, one works for the federal government. I have to say, I think this goes back to kind of impeachment and conviction and taking their time. I'm not convinced Trump wasn't more involved in the attack on the Capitol than we currently know. I have no proof of that. It's just my gut intuition. If that evidence were to come out, that he was in fact, in some way privately behind the scenes, encouraging them, inciting them, telling them to go kill Pence, go kill Nancy Pelosi, then I think all kinds of criminal charges should obviously be brought. I want to say one last thing about this. There is great reporting by the New York Times and the New Republic that show, and I think Jonathan and I have gone on about this on Twitter a little bit, but it was years ago. There is great reporting that suggests Trump's financial problems in the 1990s, when banks wouldn't lend him and he was going bankrupt and all that stuff, were cured by the Russian mafia buying his condos and all kinds of money laundering that, according to the reporting, is actually very hard to prosecute because of the way the federal laws about money laundering and real estate are written. It's a really complicated subject. But I'm pretty convinced he committed crimes in the 90s. I think the New Republic and New York Times reporting is pretty convinced he committed crimes in the 90s. They're just hard to prove. I hope the New York District Attorney is able to prove them. And in that case, I would be all in favor of prosecuting him for whatever financial crimes he may or may not have committed in the 1990s.
Perfect, thank you. And so we do have a few more questions rolling in. So one of the questions that was just posted was, do the panelists have opinions on whether Congress people can be expelled for alleged involvement in the attack on Congress?
I think
Can they be? Yes. I mean, they can. I think that Congress historically has been very reluctant to do that. Even Section 3 of the 14th Amendment was used, if I recall correctly, to expel a socialist who opposed World War I at the time, and I think that's generally recognized as a bad precedent. Now, if there were these stories going around, and who knows if they're true, that maybe a member of Congress, on the day before the riot and storming of the Capitol, was giving tours to people with the knowledge and intent of giving them the lay of the land. Now, if something like that were proven, it would certainly justify expelling a member of Congress. As much as I disagreed with and was critical in real time, for example, of Senator Hawley's remarks, I think expelling a member of Congress for something like that is not something I would be in favor of. And I say that as someone that thought that some of Hawley's remarks were frankly dishonest. But I don't think I think we have to be very careful about going down a slippery slope where folks will feel that expulsion is really just a way of operationalizing political difference. So I would have a very high bar before I would support expulsion.
Yeah, this will be dull, but I agree with everything Jonathan said. I just add one more argument to support his argument, which is the Supreme Court pretty clearly indicated in a case called Powell versus McCormick that the expulsion vote is not judicially reviewable. Now, in that case, Congress excluded somebody before they took the oath, and the Supreme Court said we can review that exclusion. But in that same case, they said expulsion, probably not. So there's really no remedy for a politically motivated 2/3 expulsion of a member of Congress. So I think that should really, really be done very carefully and only on the kind of evidence Jonathan suggested.
Perfect. And to kind of round out the discussion, so what do we see President Trump's role being in the future, particularly as it relates to whether or not he's involved with the Republican Party and, what his next few years might look like?
Let me give a quick 2-minute answer because then I have to go. But Jonathan should feel free to stay to give him, because I have class and everything. That's the same, a very similar question to we had earlier. What do we do if Trump and his base? Like how politically, and what's he going to do? He's probably going to start a TV station or radio show or something. How we deal with that is going to be very, very important. And my hope for the world is that the investigators who are investigating Trump turn up such compelling evidence of misconduct that only the very fringes of his base still believe in him, and Fox News turns away from him. I suspect, and I hope, that Hannity and Carlson and the horrific Laura Ingraham, who is a Justice Thomas clerk and as horrific a human being as has ever been, all three of them, I hope, turn away from Trump over the next year, and I suspect they will. And if they do, that'll go a long way. I'll listen to Jonathan's answer for 2 minutes, but then I got to go. So let me just say thank you to ACS, thank you to FedSoc, thank you to Jonathan for being here. I have to go to class, but I'll listen to Jonathan for 2 minutes.
I think some depends obviously on what happens in the Senate with the impeachment trial and whether or not he's convicted. And now, if he's convicted, which requires a 2/3 vote, it only would require a majority to then disqualify him from holding future office. But you have to convict before you can disqualify. So some depends on that. I think some depends upon where he where he seeks to reach his audience. At present, he's not able to get on a lot of large private social media platforms, and that certainly affects his reach. And it'll be interesting to see whether or not his followers are as interested in him when he is not on the news all the time. And we should remember, and I'm going to blank on his name, the CNN executive who has said this flat out, right? That cable networks thought he was great for ratings when he first started running for president. He's been great for ratings the last 4 years. Are they going to give him the oxygen that they did or not? Are folks that argue, I think, with some justification, that it were not for CNN's decision to put him on as much as they did in 2016, 2016, the primaries might have been different. Obviously, if there are prosecutions of any sort, that matters too. And that I think remains to be seen. My view on that is, if Trump is guilty, I hope that they can find the evidence and prosecute him. But I don't know enough about his financial dealings to know whether he has in fact committed crimes. I know that he has done enough that multiple prosecutors are interested in investigating. And I hope that they treat those investigations like they would anyone else. That is to say, if they find evidence of wrongdoing, I hope they pursue it. If they do not find evidence of wrongdoing that would satisfy a court, I hope they don't pursue some sort of show trial. But I think that obviously will affect what his standing is going forward. And so those are some of the things that I would look at.
Perfect. And Professor, if you'd like to maybe touch on the social media kind of issue, basically, like, is it an issue that social media companies were able to, censor President Trump, or do you have any thoughts generally about the entire social media situation?
Well, I mean, I believe the social media companies are private companies. I think they are allowed to adopt their own policies and should be allowed to adopt their own policies. And they are allowed to be have policies that are not politically neutral. I'm not sure that's a good thing. I'm not sure it's good for them to adopt non-politically neutral policies. Right? I do think that it is reasonable to ask, why is Trump banned from Twitter? But why is the supreme leader of Iran, who spews all sorts of false anti-Semitic and violence-encouraging rhetoric, allowed to still be on the platform? I think those are reasonable questions. But I also think that, barring any evidence of truly anti-competitive conduct, that would raise antitrust concerns. I think the reality is that if these platforms do not provide environments that people want to participate in, then there is room for alternatives like WeMe or what have you to emerge. I also think that what a lot of people don't realize is that if Section 230, which is talked about a lot, were repealed, the result would not be less moderation on these platforms. The result would be more moderation on these platforms. That is to say, if the liability protections that Section 230 provides did not exist, that they would be far more aggressive in deleting messages, policing content, policing language that might be seen by some as encouraging violence. And so I'm not sure that's a good idea. So bottom line is, I think there are a lot of reasonable bases to criticize Facebook and Twitter for their algorithms, for the way they've exercised their moderation decisions. But I don't think the answer to that is having government substitute itself for those decisions. And I think that what really matters is whether we have a broader economic environment in which these platforms not only compete with each other, which they certainly do, but also are open to competition from new entrants. And the existence of things like TikTok, I think, is evidence of the fact that Twitter's position and Facebook's position and Instagram's position and so on are not permanent, and that it is possible to compete with them, and that's where we should look for that discipline to come from.
Perfect, thank you. And then one other gentleman is asking, so why haven't we seen more serious charges against the people who stormed the Capitol? So specifically, he, is questioning maybe why not treason is being looked at specifically.
Yeah, well, I don't think the requirements of treason are met. Treason is defined in the Constitution. There's a very high burden there. I think what's been occurring, and some of the federal prosecutors have said this, is that in a case like this, where there is a desire to get charges filed quickly, you file the easiest charges first. So if the people are in the system, so they've been charged, they can be indicted and so on. And then as additional information is collected, you can add additional charges. So for example, charges about unlawful presence in the Capitol or having entered it unlawfully and so on, that's really easy. And so a lot of those charges get put in something as placeholders. If you want to add something like a charge of seditious conspiracy, which is, as is defined in federal law, would require, among other things, involvement with other people, communication and agreement with other people. Well, that there's a certain degree of evidence gathering which is necessary to make those charges stick. And so as they're working on obtaining and going through social media records, phone records and the like, it takes time for those charges to be brought. Last I looked, we are in the hundreds of charges that have been filed, hundreds of folks that are being investigated. But we should know that this sort of thing often takes time. And a lot of times, if you just round people up at the beginning, as has been occurred in some instances, a lot of those charges end up getting dropped. I think the view here is that the prosecutors want, at least my impression, and certainly from the statements that I've seen, is that the goal is to bring charges and then make them stick. And that often requires taking a certain amount of time, making sure that before you bring the larger charges, you have the evidence of it. And the various sites that have been keeping track, these and there's some Twitter accounts where folks have just been doing long Twitter threads of this. The number of charges that are being brought, the number of people that are being indicted continues to go up, and I expect will continue to go up in the weeks ahead.
Perfect, thank you. And this will be our last question. So it touches on kind of how a pardon functions. So one person, Bryce Boggs, is asking, can the people that Trump pardoned be charged with other crimes arising from the same conduct? So, how does that function? And, with future crimes that may be brought for charges?
So the pardon power is the power to pardon offenses against the United States, federal offenses, and that's understood to apply to federal law, including the law of the District of Columbia, but not to state law. So as an initial matter, if a given course of conduct was criminal or potentially criminal under both federal and state law, the pardon does nothing to affect the potential state charges. So for example, one of the more controversial pardons this week was that of Steve Bannon. Some of the allegations of fraud that have been brought against him would be violations of state law as well. My understanding is that he is under investigation for state law charges as well. The pardon does nothing to affect those state charges. One implication of that, and this is important, and this is something that I think is mischaracterized on Twitter and on cable news sometimes, is people often say, well, once you're pardoned, you no longer can claim the Fifth Amendment against right against self-incrimination. And that's not necessarily true, again, because if conduct is both a criminal at the federal level and at the state level, a federal pardon does not relieve you of the potential jeopardy under state law, and so you can still invoke your Fifth Amendment right so as not to incriminate yourself for purposes of state law. In terms of how whether or not someone could be charged federally really depends on what the pardon says. So pardons are generally understood to specify the conduct or actions or events that are being pardoned. And there is some debate about how broad or open-ended pardons can be. Michael Flynn's pardon, for example, was quite broad. The broadest pardon on record is actually Gerald Ford's pardon of President Nixon, where he basically sought to give him a blanket pardon. That was never challenged. There are some scholars who believe that the lack of specificity is actually a problem, that in order for a pardon to actually be a pardon, it has to specify the actions, events, or offenses at issue. But certainly, if you are pardoned and there was something else that you did that was criminal and it was not referenced or alluded to in the pardon, there would not be any barrier to your being prosecuted for that. It really depends on what the pardon says, and there may be individuals who received pardons where federal prosecutors may seek to go after them for things that are tangential or adjacent to, and again, that it will depend on what the pardon says. Were you pardoned for a specific act? Charges related to certain acts, charges related to certain investigations, which is the way that the Flynn pardon is phrased. Those are the details you have to look at for each pardon.
Thank you, Professor, and thank you all who attended this event. It was an absolute pleasure hearing Professor Adler and Professor Siegel. The Federalist Society will have a recording as well as, I believe, ACS. So from both of the GSU Law chapters of Federalist Society and ACS, we just thank you for spending time, and we hope you have a great rest of your week.